Good morning and welcome to today's webinar, Open for Business, Navigating COVID-19's Impact on Reopening Businesses and Returning Employees to the Workplace, presented to you by Quarles & Brady. My name is Kelly Davis and I'm a member of our firm's Labor and Employment team. I'm co-presenting today's webinar with my partners in Quarles & Brady's Labor and Employment Group, Gary Clark and Chris Nichols. My practice focuses on all areas of employment law, both litigation and counseling, representing employers. I often appear in federal and state courts. I handle administrative matters before state and federal agencies for employers of all sizes in a wide variety of industries. Gary, Chris, and I have been very busy since early March providing advice to employers through the myriad issues raised during this COVID-19 pandemic. And today we'll provide guidance for employers beginning to reopen their businesses and returning employees to the workplace. Gary?
Thanks, Kelly. I'm Gary Clark. I'm the office chair for the Chicago Labor Employment Group, a partner in the group, and spend a lot of my time counseling employers on a national basis, as well as handling complex employment litigation matters. And not surprising, like a lot of you, I'm finding myself doing a lot with all things COVID-19 related lately. So hence, with all the questions we've been getting, we thought it made sense to have a webinar and share what we can with everybody at one time.
And I'm Chris Nichols. I am a partner in the Milwaukee office. I focus on employment law, advising employers on a broad range of labor and employment issues, wage hour, workplace safety, OSHA, discipline and discharge, leave and accommodation, and it runs the gamut. But like Gary and Kelly, I think I'm really just a full-time COVID practitioner, at least for the last 6 weeks and perhaps for several more. Kelly?
Now let's start by taking a look at today's agenda. We're going to address many considerations for reopening and workforce reentry for your employees as they return from telework assignments. This is really a three-step process as we see it, starting with how you can plan for reopening, then how you return the employees to the workplace, and then finally some steps for you to follow after you are actually reopened. We're going to give you an update on the Families First Coronavirus Response Act, the provisions for paid sick leave and expanded FMLA, and how those leave entitlements interact with other leaves such as regular FMLA. We'll take a closer look at workplace safety guidance and also address employer liability concerns. We're going to give you a glimpse into some of the first lawsuits that have been filed in this area. And then finally, we'll address the WARN Act and COVID-19 specific situations to the extent that your business cannot reopen or you cannot return your full workforce when you do reopen. And with that, I'll turn it over to Chris to get us started.
Thank you, Kelly. I appreciate that. We've got a lot of material to get through today, so we will dive right into things. So first, we're going to start by discussing the considerations for reopening and workforce reentry. So right now, pretty much everyone in America has, or many businesses in America have been under some form of stay-at-home order. Some haven't. Many have. And the discussion is, what is the lifting going to look like? What is the return to work going to be looking like? How are businesses going to, in a gradual sense, return to normal operations? And what are the many things, both practical and, for the purposes of this webinar, legal, that businesses need to be considering as they prepare for workers physically to return to the workplace? One thing to keep in mind is, we've never really done this before, and by we I mean all of us. This is a big situation. We've never had a large segment of the economy shut down and reopen with such uncertainty. So, it creates a lot of questions and thinking through that employers just haven't had to do. And so it really results in a lot of interesting facets. Before proceeding, I want to give a quick update in terms of where the various stay-at-home orders are, at least with respect to where I, Gary, and Kelly sit. We all three of us sit in different states. So here in Wisconsin, which is where I practice, we've got our safer at home order in place until Tuesday, May 26th. That's less than 3 weeks away. The announced Badger bounce back, that's the plan for how we're going to reopen the Wisconsin economy. It's going to be done in phases. That much we know. We don't know a lot of detail, but I will share with you what we know so far, which is that on or after May 26th, phase one, assuming things aren't continued in a stay at home, phase one will limit gatherings to 10 people, will loosen restrictions on non-essential businesses. Some restaurants will be able to be opening, and there will be social distancing. Phase two, you're going to look at groups limited to 50 people, increased opening of non-essential businesses, continued social distancing. Phase three, there will be much less protective measures except for the vulnerable populations. That's about all we know so far. We don't know how long those are going to last, what the specific details are going to look like, and whether there will be interim loosening in between. Notably here in Wisconsin, the Wisconsin legislature has mounted a legal challenge to the safer at home order that is in effect for 3 more weeks. The oral argument on that was heard by the Wisconsin Supreme Court yesterday. We expect a decision soon. Sort of the most extreme example could be the Wisconsin Supreme Court saying we're killing the safer at home order, or maybe there would be something more orderly. We don't know yet. We expect something soon on that. Gary, can you give us a quick update on the Illinois stay-at-home order?
Sure, Chris. I mean, what I can share is that we've been in our shelter-in-place orders since approximately March 20th. We're extended through the end of the month. Yesterday, our governor handed down a 5-phase plan for returning to the work and reopening the economy. And each phase is basically tied to the number of hospital beds available, the infection rate, and certain things in place with regard to contact tracing and things along those lines. So that makes things a little challenging for the clients I've talked to already about it, because they don't have specific dates, which is what people generally like to work with when they're trying to plan for reopening the business. I can say that of the 5 phases, we're currently in phase 2, the flattening the curve, which only essential businesses are open, and a few retailers that are non-essential but providing curbside pickup are open. Phase 3 is really the one that I think most people in this call are interested in, and that's when we're going to have more of a general return to manufacturing and offices and things along those lines. But again, to get there, we have to have 28 days of stability with hospital admissions and infection rates that are under a certain percentage of all tests. So we don't know when we're going to get to phase 3. The other challenge for clients I've talked to, and I'm really hoping this is going to change, is currently we don't open schools or childcare until phase 4. And at least the clients I've talked to have questioned, how are we going to get our workers back if they've got kids at home and the daycares and the schools are closed? So I'm really hoping the state realizes that they may not be able to reopen manufacturing until schools and childcare are opened, and that we may see some revisions to that. And phase 5 is concerts, sporting events, back to life as normal. So that's what we've got in Illinois, and I can report as of today. Kelly, how about Florida?
Thanks, Gary. Yeah, Florida is following a 3-phase approach to reopening. Our safer at home order went into effect on April 3rd and was extended until this past Monday, May 4th, when we entered phase 1. 3 counties in Florida, Miami-Dade, Broward, and Palm Beach on the East Coast, are not yet reopening. They have the highest concentration of cases. But phase 1 allowed dental and other medical offices that were previously closed to reopen if they're able to meet certain conditions related to having appropriate PPE on hand. Elective surgeries can resume in phase 1. Restaurants and retail were permitted to reopen with significant capacity limitations. It's a 25% limitation. Businesses like bars, nightclubs, gyms, salons, and any of the other personal care services are still required to remain closed in this phase one. A lot of our beaches in Florida and municipal parks, for the most part, were never covered by the governor's order and were subject just to rules from local authorities. So many of those beaches have reopened. We don't have a date or even know what the triggering event is in Florida for when we move to phase two. So all we know is that there are some businesses that have reopened or permitted to reopen this week, and we'll wait and see what comes next.
Okay, thank you, Kelly. So let's talk about some of the specifics of preparing for a workforce reentry. Obviously, it's important to have key decision makers involved, a multidisciplinary group who creates and communicates the reentry plan. You need people from HR, people from IT, people from all the different various sort of decision centers that will be responsible for evaluating, implementing, and revising protocol that relate to and surround the things that we're talking about today. Cleaning and disinfecting. Just 1 week ago, the CDC issued very good guidance on cleaning and disinfecting. They provide a link to the Environmental Protection Agency's website, which provides a list of products that work, and it tells you how to read the EPA registration number on the product label so that you ensure that to the extent you are, well, not extent you are, you will be increasing the frequency of cleaning and disinfecting, especially frequently touched areas, commonly touched areas. You need to give consideration to things like what items can be moved or what items can be removed so that you can reduce handling or contact, and the nature of which you are cleaning. So whether you're cleaning a porous material or non-porous material, the CDC website goes through all of that. It's right on the front page. So the person who's part of your group to make decisions about that should be reviewing that and making sure you are following those changes. Physical changes. This is a big one too. We know that social distancing is going to be here with us for a while. That's part of all of the different types of phases you heard that are anticipated in Wisconsin, that are being put in place in Illinois, in Florida, and many other states. So things like closing communal spaces, staggering lunch hours, physically removing chairs in the lunchroom so that they're 6 feet or greater apart, repositioning workstations, that needs to be thought of. Certainly with respect to office workers, there may be more flexibility in being able to reposition workstations. With respect to manufacturers, it may be more difficult if you've got mounted equipment, but that needs to be given significant thought. Staggering meal and break times so that there is not everyone piling in at one time. Staggering shift times so that people aren't all in the locker room at one time or not all at the time clocks when they arrive or depart at one time. Those are things that need to be given due consideration to, and this is all going to be very important because as the virus continues to be present, even once we open the economy back up, we as employers want to make sure that our business can run smooth and is not significantly impacted. That's the hope, is not significantly impacted by community spread of the virus. And the more things we do here, the much more effective we're going to be in having a healthy, safe workforce. Limiting gatherings, limiting visitors, signage. There are a number of companies out there that are generating signs and floor markings. You've seen them at the grocery store showing the 6 feet distance. You might consider putting things like that into elevators or other areas of the workplace. Another area to consider is with respect to hallways, whether to make hallways one way to the extent that's possible, so that there is not cross contact and workers, sort of repeatedly walking past one another. For other types of work environments, strip curtains, plexiglass, similar types of materials that include an impermeable divider or partition. Throughout the presentation, we're going to talk about the various sort of specific applications of that, but those are things that employers should be thinking about. So too with cohorting, which is sort of grouping workers together. So if we've got shift workers, groups of workers who are cohorted, they're always going to be assigned to the same shift with the same coworkers. That can reduce the spread, or at least limit the spread within that cohort and the number of workers who are possibly quarantined in the event that there is an infection and it spreads. Just make sure I get the slide here. Okay. This slide I'm not going to spend too much time on because we're going to talk about PPE later on in the presentation. The sort of bottom bullet, though, I think that's important. Hand sanitizer, soap, disinfecting wipes, all of that needs to be readily available throughout the workforce, regularly checked, making sure it's being refilled. As I noted, PPE, I'm going to talk in sort of greater detail about that and sort of OSHA implications later on. So we'll go to the next slide, which is discussing establishing the COVID-19 screening procedure. So it may be a good idea, or states may require employers to develop procedures to prevent symptomatic or potentially infected workers from entering the workplace. Well, the two sort of big ways to do this would be through temperature testing and self-reporting. Again, I'll talk in greater detail about temperature testing, so I'm not going to go into significant detail here, but let me start with self-reporting. So this is particularly important particularly for employers who are going to re-engage with their workforces, whether they have been out of work, the employees have been out of work, or the employees have been working remotely, and we're going to be bringing them back onto the site. There should be, asking workers to confirm that they are asymptomatic and have not been in contact with anyone who is symptomatic. Quarles and Brady has prepared documents that employers can use to distribute to their workers to help them, basically checklists to help them self-identify. That's an effective way to sort of answer yes, no as to whether someone meets the CDC criteria for a recent exposure or not. Temperature testing, we're getting a lot of questions on that, and we'll talk about temperature testing in greater detail in a little bit further down the presentation. But temperature testing, if we do it at the work site, there's a number of ways. Sort of physically, you can ask employees. Employees can be asked to take their own temperature at home, or if there is going to be temperature testing implemented at the workplace, you can have a barrier or screen where the screener is standing behind the physical barrier and then reaching around the barrier to perform the temperature testing, or you can have the screener rely on personal protective equipment, face mask, eye protection, disposable gloves, perhaps a gown if there's going to be prolonged exposure, because keeping in mind that if we're asking an employee to conduct temperature testing on other coworkers and there is no physical barrier, that employee who we've instructed to be the screener is going to be within 6 feet of a lot of workers for a prolonged period of time. Again, I'll get into that in a little bit greater detail when we talk about the workplace safety. It's interesting that we're talking about things like this in the first place. Normally, if you call your employment attorney and say, hey, can we conduct things like temperature testing, et cetera? No, that's not normally the case. But here, the EEOC has recognized that COVID-19 is a direct threat, and so it allows employers to take sort of measures that they wouldn't normally take. And some of those measures, moving on to the next slide, include well, I shouldn't say measures, I should say to the extent we are doing things like gathering temperatures, we need to nonetheless be careful to the extent we are retaining that information. That is, it is considered a medical procedure, or a medical exam, at least under the EEOC's definition, and the information that we collect, the temperatures, is confidential medical information. It needs to be separately maintained. It needs to be not disclosed except for limited need to know bases. Things with respect to anti-discrimination issues with respect to testing that need to be considered is that, we're not just picking and choosing who to test. We're going to test across a broad job category, or, all workers. And to the extent we're conducting tests, we would need to be paying for that. In the event that an employee is refusing to participate in testing and temperature testing or something like that, we may prohibit those workers from refusing to enter the workplace. Like with other equal employment things, there should be, we should give considerations for legitimate medical or religious reasons, and that, of course, would be handled on a one-off basis. Continuing with preparing for workplace reentry, it's important to think through the policies that we have in place and whether we need to implement new policies. Gary will talk extensively about the Families First Act, but what about things like social distancing, hygiene practices, reporting COVID-19 related concerns, attendance, telework? Those are the sorts of things that your task force should be thinking through. Do we have a workforce that's going to sort of abide by social distancing, or do we need to put a work rule in place that actually enforces social distancing to the extent it is reasonable, and consider potentially providing discipline for people who sort of flagrantly or repeatedly violate that? Now I want to move on to the next step, which is the returning employees to the workforce. And I will turn the slide over to Kelly for that. Kelly?
Thanks, Chris. Now that you all have the tools to plan for the return to the workplace, how do you actually bring the employees back? Well, we suggest that you consider bringing employees back in stages if that is something that would work for your business. Are there employees who have been successfully teleworking and can continue to do so for the time being? We don't know how long, but we think the best advice here is to consider not going from 0 to 100 all at one time. If you are able to return employees in stages, you need to have a neutral, non-discriminatory plan for how you're going to do that. You want to avoid, of course, any claims that the manner in which you returned employees to the workplace favored employees of a certain category. If possible, and at least initially, consider whether you can make the return to the workplace voluntary. Gary mentioned Illinois stages. Schools and childcare facilities aren't going to open at the same time many businesses can open. And so having a mandatory return to the workplace may create issues that some employees just simply can't return because they don't have the means to do so. You're also going to have sort of a wide range of employees with a wide range of emotions about returning to the workplace. And so a voluntary return, will let the workers who just can't wait to get out of their house and don't have other considerations tying them to the house, come back to the workplace first, and they're glad to do that. And you may have other workers who are very thankful for the opportunity to continue to telework for some unknown amount of time. Make sure that your HR team is prepared to answer any benefits related questions. there's likely to be many questions, especially if you've been shut down because you are a non-essential business. And just to go back, one point I don't want to miss here is, if you have unionized employees, make sure that you're complying with the collective bargaining agreement as you bring employees back. That's something very important that you need to focus on. When you bring the employees back, obviously you need to notify them that they're going to be asked or permitted to return to work. And so we think that the notification should cover some very important topics. First and foremost, if you can boost employee morale through this notification, take that opportunity. Acknowledging and thanking employees for their sacrifices and hard work during this very difficult time, that really goes a long way for employee morale. Let them know that you're looking forward to actually seeing them back in the workplace at the appropriate time. You'll, of course, need to provide the specifics for when you expect them to return, being the specific date, explaining if there's staggered returns, if you're making any schedule changes so that you have employees spread out throughout the workday in terms of taking breaks and things like that. Of course, if you're implementing any new policies and procedures, which we've obviously recommended that you consider doing some of them, if not all of them, you need to let the employees know what those are, not only so that they have the information before they're asked to show up and have their temperature taken or complete a questionnaire about whether they have symptoms, but just also so that you provide them with the level of comfort that many are looking for, knowing that you're taking this seriously, which we know all of you are based on the questions we've received, but also just so that the employees can get that comfort level. And we think it's important that you give them a resource for who they can ask questions to about COVID-19 and the return to work. Likely to be someone in your HR department, but even if you call out a specific person, that would be very helpful. You should expect that you're probably going to receive some requests from employees who say they need to or really want to continue to work from home if they've been doing so. And you may also get questions from employees who say, I don't want to come back yet. So what we think you need to do in that situation is engage in a discussion with the employee to find out why they're making that request or why they're refusing to return. You might need to go through an accommodation analysis. You can definitely ask questions here to determine if they have a disability and if some type of underlying medical condition is the reason for their desire not to return to the workplace yet. The EEOC has been updating its guidance, trying to address the COVID-19 specific situations. Some guidance went out yesterday and quickly got removed due to alleged misinterpretations of that guidance. So we expect further guidance from the EEOC on this really anytime. If an employee is not coming back to work, you're obviously not obligated to pay wages, absent some somewhat unique circumstances. You're not necessarily required to let them use regular PTO unless your policy says otherwise. And it may be that the employee is not qualified for the FFCRA sick leave. Gary will talk a little more about that coming up here. One word of caution, avoid the temptation to sort of immediately respond with discipline or termination because the refusal might be some type of protected activity. Once you've reopened, I should say, you should be communicating regularly with your employees, maybe as often as every week or multiple times during the week even, depending on what the circumstances are. You might need to revise and update your policies, so you'll need to potentially change your staggered return plan if you need to slow it down because of changes in the workplace that you're seeing. Of course, monitoring your workplace for signs of infection and being ready to take quick, appropriate action in the event that you have any potentially infected or symptomatic employees in the workplace. Your policy should really outline the expectations for your employees, which first and foremost are stay home if you feel sick, and describing when and how they can return if they had been sick. You'll need to determine, which other employees must be notified of a possible exposure if you have a workplace situation, and what you expect those potentially exposed employees to do once you notify them of the exposure concern. And finally, I think the communication, you should know what communication you'll send if you do have a positive COVID-19 case among your workforce. Are you going to send a company-wide message? Are you going to limit it to a specific work site if you have multiple work sites? Or are you just going to share the information with those who have been exposed or potentially exposed to the employee with COVID-19? You know, any of those can be the right answer, but you need to have decided what is appropriate for your workforce. And if I can get the slide to advance, there we go. When you reopen, I think you should be prepared that you may see spikes in absenteeism, and to avoid business interruption, cross-training employees to make sure that key operational aspects are covered or certain job responsibilities can be covered by other employees will help you avoid further disruption, because this has already caused significant disruption to your business. Make sure that you're following all public health guidance. It is changing. It will continue to change. So identifying someone in your HR department or on a safety team or something like that to be the person responsible for trying to stay updated with the latest guidance will help ensure that you don't miss important updates. And then, you know, we want to suggest that you look for ways to boost employee morale. This has been difficult for everybody from the top all the way down. And like I mentioned before, a little bit of recognition of that fact kind of goes a long way. And then finally, make sure your HR team is properly administering the FFCRA and other leaves in these situations. And for more on that, I will turn it back over to Gary Clark.
All right, thanks, Kelly. You know, for those of you who are just opening up now, you're not going to experience all the fun we had at the beginning with the FFCRA, in that we had a law and we didn't really have any regulations or guidance, and it started trickling out from the Department of Labor in the last week of March and the first week of April. And as we were advising clients on it, we started seeing that some of the answers were changing, that the Department of Labor in the cover of night was going back and re-editing and revising their guidance to, in some instances, contradict what it had said a few days ago. That's ended. Things have stabilized. For those of you who are now saying, hey, what is this, you know, Families First Coronavirus Response Act thing that we have to deal with now that we're reopening the business, should be much, much smoother sailing for you. So here are the basics. It applies to businesses with fewer than 500 employees. There are exclusions that are available if you're under 50 employees for the FMLA provision. There are exclusions for healthcare providers, which is defined very broadly, and emergency responders. The basics: it provides for Expanded Family and Medical Leave Act, and it provides for 10 days of paid leave for qualifying individuals. So who qualifies, right? Who gets, well, for paid leave, you get up to 10 days for employees who, one, if they're subject to a federal, state, or local quarantine or isolation order related to COVID-19. Now that seems simple enough, but what we've seen in the guidance that's come out is, for instance, even though we may have an order in Illinois in place, if the business is open because it's allowed to be open, if the business is closed and there's no work for the employee, whether it be because they're furloughed or the business is closed, then they're not entitled to this leave. The employee is only entitled to this leave on this basis if they are, if there's work available for them, but they're unable to work due to a federal, state, or local quarantine or isolation order, which is a very, very narrow category of individuals. The others are much more straightforward. You've got people who have been advised by a healthcare provider to self-quarantine related to COVID-19, people who are sick with COVID-19 symptoms, people who are caring for people who are subject to a qualified quarantine or isolation order, or people who are caring for children whose school has been closed or their childcare provider is unavailable. These are the individuals that qualify for 10 days of paid sick leave. There's also an expansion to the FMLA that makes it paid for individuals who are unable to work because their child's school has closed or the child's care provider is unavailable closed due to COVID-19 related conditions. So we've also got that. Now, the one key that we've got in red at the bottom of the slide, and I had it on the previous slide too, is if you're going to pay out this benefit, you get a tax credit on your payroll taxes. But the only way to get that tax credit for what you're paying out is to have documentation to support that the employee qualified for the leave. And so that raises, what's the next question that comes to mind? Well, what do we need documentation wise, right? This was one of the questions that came out frequently in early April from clients. So what do you need to document? Some of this is obvious and common sense. Employee's name, the dates the leave's requested, the reason for leave, and a statement from the employee that he or she's unable to work because of that qualifying reason. So if the employee is sick with COVID-19, you need a statement or documentation that's the reason, and that the employee is unable to work because of that reason. If the employee's been advised to quarantine by a healthcare provider or is caring for someone who's been advised to quarantine by a healthcare provider, you also need the name of that healthcare provider. And that's at the very least. Most clients are just simply asking for doctor. If someone's been advised to quarantine is the easy way to get the documentation for this, or a doctor's note for the individual being cared for. But at the very least, you need the name of the healthcare provider to get the tax credit. So, and if the individual is qualifying for leave based on a school closure or the loss of a child care provider, then you need the name of the school or the place of care or child care provider and a statement that no other suitable person is available to care for the child.
Hi, Gary, this is Chris.
means,
I have a question about this, the expanded FMLA for child care leave. What about someone currently on leave, expanded FMLA for child care? What happens when the school year ends, which is coming up real soon?
Chris, that's a great question. And I really, really appreciate the way you read that it didn't sound scripted at all or planted. So that was awesome. But what I would say is, the closure of the school has a qualifying basis when the school year ends. So does that basis for the expanded emergency FMLA leave. Now, it may be that the employee has lost a child care provider for those summer times as well, and it just may mean you need to requalify them at that time. So that's how to handle that. I've got this one set out as a separate Q&A or frequently asked question, just because it's tricky. There is no 30-day waiting period for the paid leave provisions under the FFCRA, but there is a 30-day waiting period for the expanded FMLA when there's a closure of a school or a loss of a child care provider. And what's a little tricky with that is if the employee's been on furlough, they can still qualify for that 30-day waiting period if they had 30 days seniority prior to going on furlough. So don't let that trip you up if you bring someone back from furlough and they request leave the next day or 2 days later. So what else do we need to keep in mind? Well, don't forget that normal FMLA also applies. We're dealing with these new benefits and they get tricky as we try to navigate them, but someone who's either has COVID-19 or is caring for someone with COVID-19, if they're still unable to return after 10 days because of their own illness or caring for someone with an illness that may be a serious health condition, they're probably going to be entitled to FMLA and continued leave, which would be the normal traditional FMLA that we're all familiar with, which would be unpaid unless you have a short-term disability policy or something else providing for benefits during that FMLA leave. Remember, they may also be entitled to paid sick leave under municipal or state law, and that you've got to get that FMLA paperwork to them, soon and quickly in order to make sure it runs concurrent with these other leaves. Something else that's a little counterintuitive is when this law passed, we thought everybody would have an additional 12 weeks, even if they had previously used FMLA for a surgery or something else. The guidance has made clear that that is not the case, that if someone missed 10 weeks due to a surgery back in February and they now qualify for the expanded FMLA, they are only entitled to 2 weeks at that point. So it's only 12 weeks within the 12-month period for how you administer your FMLA. Now, I want to spend a minute or two on this, because this is, and all the clients I'm talking to as we're walking through all the COVID-19 related issues, whether it be return to work or other things we're dealing with, the ADA piece is the one that keeps getting forgotten or neglected and keeps being the one to supply the answers to a lot of the what do I do questions. And one of the things to remember is you're going to have employees with medical conditions that may require reasonable accommodation, and it may involve, employees returning to the workplace that have medical conditions that make them vulnerable to COVID-19. You may get requests to reasonably accommodate the individual by having them work from home or to make workplace modifications to prevent, decrease the risk of infection, whether that be working in an office, working in an isolated space, something else that may help that individual avoid or decrease the risk of infection. You may also have people requesting to remain on an unpaid leave or to remain on furlough as a reasonable accommodation. Depending on the circumstances, that may be a reasonable, and the request, that may be a reasonable accommodation. Similarly, when you're making reasonable accommodations under the ADA, and if you grant light work and other temporary accommodations, you're probably going to have an obligation to make accommodations for pregnant employees as well under Title VII. And that can involve allowing someone to remain out of work on a leave, that can involve workplace modifications. This is an area of the law that the EEOC has been very active in lately, in bringing a lot of enforcement actions for employers that are not accommodating pregnant employees the same as they do employees subject to the ADA. So you need to be mindful of this, especially with pregnancy being recognized as a condition vulnerable to COVID-19. The other ADA issue you've got to keep in mind is with all the folks that you've got working home remotely right now, there are going to be a lot of them that don't want to return to work when the workplace opens. I'm seeing this already with clients that are planning to reopen, and they're starting to get ADA requests from employees to remain working remotely, even with return to work, based on their medical condition. In some instances, it's easy to grant. It's a job that can be performed from home. In others, it's a lot more tricky. And I will say that the argument's gotten a lot tougher to defend as an employer that someone can't work from home when they've been doing it for the past 7 weeks at this point. So have your ADA process in place, have your ADA team ready to be part of the return to work planning and helping making decisions about how you're going to handle these issues. So with that, workplace safety is always going to be at the forefront of all of this. And so with that, we'll turn it over to Chris.
Thanks, Gary. Make sure I'm on the right slide. Okay. So, as you know, obviously workplace safety is of paramount concern. We're talking about a virus that is a public health problem and is making a lot of people sick. One of the sort of things that might not be on employers' mind is the recordability of a positive COVID-19 test if a worker is infected as a result of work-related duties. This is your OSHA 300 logs and your obligation to make a recording in your OSHA logs for someone who becomes sick as a result of COVID-19. Now, OSHA admittedly wavered, quite a bit on this one. By way of background, normally when an employee becomes sick with whatever sort of sickness, the flu or whatever it might be, that's not a recordable event from an OSHA perspective. In March, OSHA issued guidance saying, no, we want COVID-19 to be recordable. There was a lot of pushback, particularly because, it's very, very difficult to establish whether someone's catching COVID-19 was work-related or not, depending, of course, on the work environment and the circumstances. I mean, it's invisible. You can't see, you can't tell. So what OSHA did was they backed off of that and they made it industry specific. And for most employers, the only instance in which the employer would need to record a COVID-19 positive employee test as work related would be if there's quote unquote objective evidence that's reasonably available to the employer. And the most likely scenario for that would be if one person tests positive and then 3 more who worked within repeatedly or continually within 6 feet of that first person. That next group of 3, it might be hard to say that they were not work related. This sort of underscores the importance of the things we talked about at the top of the presentation, which was the social distancing and the importance of doing that. The more distancing and other protective measures you can implement, the less likely you're going to have an obligation to either report as work-related a subsequent COVID-19 test, or what we've seen is when an employee becomes tests positive, the relevant county health department is notified of that, and the county health department is calling employers and saying, who are all the people that this employee had come in contact with? And if the answer is large, we have to, let's say there's a large number of employees, the health department's going to ask for their names and contact information, is going to call all those employees, and is going to say, I advise that these people all stay home from work. And now you've got a major attendance issue. If your work environment has been very effectively managed with social distancing, your response then can be, well, we've got extremely effective social distancing and there has not been a large number of people who have come in contact with person A. So that is sort of how it plays out, how this social distancing plays out. Employers in specific industries, healthcare, emergency response, there is sort of an increased responsibility to report to OSHA a positive COVID-19 test as work-related, if in fact that's the case. There's a lot of talk today and now about employer immunity and whether there's going to be a federal law or something put in place that shields employers from responsibility or liability to their employees if those employees get sick. Well, that there is no federal law that's yet in place. That's still just in discussion. But what's important is the employer's current obligations. So every employer under OSHA's general duty clause has to provide a workplace free from recognized hazards. And very clearly, COVID-19 is a recognized hazard. And what I've seen a number of employers receive are letters from OSHA that were the result of an employee complaint where the employee felt that the employer was not doing its part with respect to managing social distancing, cleaning, the things we talked about at the top of the presentation and the things that are on the slide in front of you here. So, again, this is why it's important, because your response as a legal matter to OSHA when they send you a letter saying, are you doing the things? You want to be able to demonstrate in word and in fact that your work environment complied with the CDC, the CDC guidelines. That's really what OSHA is defaulting to. What is the CDC saying is recommended if you're in a particular industry, what's recommended, and are you doing those things? So that shows the importance of following the OSHA guidance. What to do if an employee reports a COVID-19 diagnosis? Well, first, let's verify the information with the employee. Let's confirm that it was a likely case. And if in fact it was, we'll take steps to remove that person from the workforce and ensure that there was no direct contact with infected employees in the last 48 hours. If there were, we would do our own contact tracing within the workforce to identify people who may have come in contact with that employee. And for those workers, we would advise, at a minimum, Kelly talked earlier about who to advise, but at a minimum, those workers we would communicate with. And that's what we're talking about here on this slide, is our responsibility to communicate with workers who have potentially had a exposure or contact to the employee who reported a positive test. So a couple of things keep in mind from a confidentiality perspective is that we are not to disclose the identity of an employee diagnosed with or suspected of having coronavirus. So we of course need to be careful. We would share not the name, but we would share with those who had recent contact that they may have been exposed. And here's what our recommendations are. I'm going to sort of go through this slide at a higher level because it's all sort of spelled out here for you, which is what can an employee diagnose with COVID-19, or I'm sorry, when can an employee diagnosed with COVID-19 return to work? There is sort of a very specific criteria. This is taken straight from the CDC webpage, and it spells out the sort of exact hours and experience requirements that those employees would need to be able to say they have met before they should be allowed to return to the workforce. Skip forward to this slide, which is, can an employer tell employees that they can't come to work after they report someone in their household has COVID-19 symptoms? The answer to that is yes. CDC recommends that we keep employees out of the workplace until, and there again, there's this sort of specific criteria for those, for whether that person meets that. Temperature testing. We talked earlier about temperature testing. A lot of employers right now are thinking, is this something we need to do, or is this something we want to do? Well, it depends. I mean, if we can really affect very good social distancing, then maybe temperature testing isn't something that's going to work in our workforce. If not, if we have a workforce where people are necessarily going to have some closeness, then maybe temperature testing is a preventative measure we want to take, keeping in mind that temperature testing is not perfect. And if we're going to, and it is not 100% indicative of whether someone has COVID or not. But if we're going to implement temperature testing, then we need to do so within the frameworks of the bullets listed on this slide, which are, applied in non-discriminatory manner, reliable temperature testing device. A best practice would be to bring in a healthcare professional to sort of as an independent contractor to perform the temperature testing. That may not be available to all workers. And so if we're going to have an employee do it in the workforce, then we would want to make sure that employee is either behind a barrier or that employee is engaging in personal protective equipment such that they are not being exposed. And again, the CDC website has some very good details on what that would look like. With respect to face masks, this is also a question that we're getting a lot, which is, there is, at least Federally, there is no requirement to wear face masks. The CDC has recommended it. A lot of employers are considering whether this is something they want to do. Again, like with temperature testing, if you can engage in effective social distancing requirements, maybe face masks are not something that is additionally needed. If you have a work environment where people are going to be within 6 feet on a regular basis, then face masks are something you strongly should consider. And keeping in mind, if you do face masks, you want to train people on the proper use, how to take them off, make sure that they wear it appropriately. It's not that complicated, but you want to make sure you've done that training so that an employee can't say, oh, I didn't realize I wasn't supposed to wear it in a particular way or not. With that, I'll turn the slides over to Gary to talk about employees who don't want to come to work.
Thanks, Chris. And this is an issue that I've been seeing more and more as I work with clients sending out communications with regard to the reopening of the workplace and bringing employees back. And what we're seeing more and more is that there are a number of employees that don't want to return at this time. And it may be due to general COVID-19 concerns. In some instances, they're scared to take public transportation if that's their only means to get to work. Some instances, it may be a concern about the workplace, that they don't think their specific workplace is safe due to facts inherent or specific to that workplace. In some instances, it can be an ADA issue that they have a medical condition that makes them vulnerable, that they want a reasonable accommodation, whether it be an unpaid furlough or whatever else it may be. And in some instances, we've seen it is simply the fact that that employer has continued health insurance, with the employer paying their share, the employees getting unemployment, that they're making nearly as much, the same, or even more than they made at the workplace, and they really just don't want to return to work and risk infection at this time in light of that. So what do you do as you start having employees say to you that I don't want to come back? Well, listen to the employees, have discussions with them, talk to them. As we've said time and time again, this is new territory. There is no tried and true playbook for how to deal with this. We're all learning. We're seeing plexiglass at cash registers for the first time in our lifetimes. We're seeing shower curtains being recommended to separate people in some instances. Listen to the employees for ideas, the things that concern them about the workplace, the things they think you should be doing, and consider modifications that are recommended. For employees that are covered by the ADA, work them through your ADA process for workplace modifications, other things along those lines, whether there are the ways they can be reasonably accommodated. And for employees that just simply do not believe your workplace is safe and are raising general safety concerns about a lack of PPE or something else specific to your workplace, recognize that concern may be protected by OSHA, that they don't believe that it's a safe work environment. And the other reason to keep talking with people to find out what their general objection is because you do want to weed out the people that simply don't want to come back because they prefer unemployment, or it's general anxiety about COVID-19 and nothing specific to your workplace, or it's public transportation, but you're able to provide benefits to enable them to do ride sharing or whatever else it may be. These are all the reasons to have conversations. And then you're going to want to talk with legal counsel, because if you're going to try and take a tougher stance with some individuals that are refusing to return, whether that be ending health insurance pursuant to your plan terms, making clear to employees that anyone that does not return is no longer eligible for unemployment benefits, that you will be contesting benefits, or making clear to employees that they don't return now, they have no right to reinstatement because you're going to have to hire a replacement for them. Whatever strategy you decide, you've got to work with legal counsel to make sure you're not accidentally retaliating for protected rights. One thing I want to point out is that we are at 11:30 right now, and this is our end time. For those of you that have to drop off, we understand. You can submit your CLE credit and get that approved. We're going to continue because we have so much content and this is such a topical issue that we're getting phone calls and emails on nonstop every day. So for those of you that can stay with us, we will keep going to try and get through all these materials. For those that drop off, we will offer a recorded version of this with the materials. If you need to jump on a call or go anything like that, you can listen to the last part at that time. And we promise to move through these remaining slides as quickly as possible, just out of respect for everybody's time. So the slide I've got up now is just that even apart from individual employees, there's questions right now about whether union labor is going to return. The AFL-CIO has been very vocal that their workers are not returning until certain conditions are met that will guarantee them a safe workplace. Those conditions include enforceable workplace health and safety standards in place, which OSHA has pushed back on and not been willing to do. Stronger anti-retaliation protections for employees that express safety concerns, and a massive increase in the quantity and the types of PPE. So even for workplaces that may not have had it previously, they're looking for that and for additional PPE for other workplaces and in sufficient quantity for everybody that needs it. Are all things that they want in place before they'll return. Again, this is just a reminder, this slide, that OSHA has handed down guidance for certain industries. Have someone on your team checking regularly to see for any updates for your industry, any updates on the CDC, any updates for OSHA, any of those. And why do you want to do that? Well, because one of the great unknowns we've got now is what is going to be the employer liability going forward when employees are forced back into the workplace or returned. And there's been a lot of speculation that employees who get sick with COVID-19 are going to claim that they got the infection in the workplace and file workers' comp claims. And, you know, in theory, that makes a lot of sense, and that's probably preferable to civil lawsuits. So the comp system covers any accidental injuries arising out of in the course of employment. If an employee can prove that they got the infection in the workplace, in theory, the state workers' comp system should cover it. I've been reading a lot of speculation that we may start seeing actual civil lawsuits seeking, you know, punitive damages and large jury verdict awards for wrongful death when you have workers that die from COVID-19 where the infection is alleged to have resulted in the workplace. And the theory would be, if you are an employer that completely ignored your responsibilities to protect employees, to all the things that Chris and Kelly have talked about that we should be doing, all the CDC guidance and OSHA that we need to be following, if you completely abrogate those responsibilities, there may be an argument that you acted intentionally and that therefore you're outside of the workers' comp system and subject to a huge, huge liability for a jury verdict. So whether that comes to pass, we don't know. Like I said, this is all brand new territory for everybody. But I will tell you, we're seeing the lawsuits filed already. You know, this Walmart one is one in Illinois that we've got where they claimed that the employee that died contracted coronavirus at work. The employer was supposedly not using safety measures recommended by the CDC, not telling coworkers that they had interacted with customers or employees that were infected. There was no extra cleaning or sterilizing, no social distancing, no PPE for employees, no masks, no gloves, no hand sanitizer, anything. And the workers had no training on what they could do to mitigate their risk. So this is right now a lawsuit in court that is trying to bypass the workers' comp system on behalf of this individual. We're seeing a similar lawsuit filed in the cruise industry, again, alleging that they completely ignored their responsibilities to maintain a safe work environment. And, you know, right here, we're also seeing lawsuits filed about individuals claiming that they were whistleblowers or that they engaged in protected activity and they were retaliated against. We're dealing with employees that claim they wanted to wear a mask, but they were retaliated against because they weren't allowed to. And we're dealing with a lawsuit that we've got for a nurse for one of the local hospitals that was very, very vocal about the inadequacy of the PPE, that the masks were inadequate in quantity and quality, and claims that that was the reason she was told not to come back to work. Amazon is facing a lot of claims like that. That is a reality, and that is something you need to be very careful about if you make any decisions to terminate or discipline an employee, to make sure you're not retaliating against them for protected activity. And with that, we'll turn this over to Kelly for workplaces that, after hearing all this, have decided, I don't want to reopen. I don't want to come back until this is all done. And she'll talk about the WARN Act.
Thanks, Gary. And besides not wanting to reopen, the economic considerations may be that you can't reopen fully, or you're going to reopen with a reduced workforce. So let's just first talk about what you need to do if that's a situation you find yourself in. The first consideration is really whether the federal WARN Act applies to your business. The basics are here on your screen on these slides. There are, of course, many nuances that, if you find that you think you meet this for enterprise coverage, then you need to probably be consulting with legal counsel before you move forward. But the basic is, if you have 100 or more employees, excluding part-time employees who work on average fewer than 20 hours per week, or seasonal employees who work fewer than 6 of the 12 months before the date that WARN notice would be included or required, excuse me, then that's when WARN Act applies. There's a second measuring yardstick here that includes part-time employees. That's a little more confusing, but something that needs to be looked at. And you should also keep in mind that many states have what we call mini WARN Acts, and some of those have lower thresholds for when WARN notice is required. So some of them are listed here on your screen. Some of them are as low as 50 employees when you need to provide notice of a planned closure or mass layoff. WARN is triggered and you are required to provide 60 days advance notice if you're a covered employer under the prior analysis. When you close a workplace, a plant closing, so it's either closing a facility or discontinuing an operating unit that affects 50 employees, again, not counting part-time workers at a single site of employment. Also, there's the mass layoff prong when you lay off 500 or more employees, or if we're talking about numbers between 50 and 499 workers, if the amount of employees being laid off make up at least 33% of your active workforce at a single site of employment, that counts as a mass layoff. The bullet here in red is sort of the factual situation that many of you may unfortunately find yourselves dealing with, which is that you announce a temporary layoff that's intended to be less than 6 months, and it otherwise affects the required number of employees under the mass layoff calculations. And then later you decide or are forced to extend the layoff for more than 6 months. Notice is going to be required in that situation. There's also an hours reduction, which may also apply if you're reducing the hours for 50 or more employees by 50% or more for each month in a 6-month period, even if that's not intended to be a permanent change, but if it has that effect for a period of 6 months, then WARN notice would be required there. Some states do have a longer notice period where instead of providing the employees with 60 days notice, you may need to provide them 90 days notice. So you're saying, okay, how the heck was I supposed to figure out 60 days before this situation came up that I was going to be in this situation? Because this COVID-19 environment that we're in has evolved rapidly and caught many people by surprise. And so there are a couple exceptions to the requirement to provide 60 days notice. 2 of them that might help you. One is the faltering company. That, the criteria is laid out here. That's probably not the best argument that businesses are going to have. It's the second one here on this slide, the unforeseeable business circumstances. And the Department of Labor has issued a FAQ on this that says a government ordered closing that occurred without much prior notice could be an unforeseeable business circumstance. It's really a sudden, dramatic, and unexpected action or condition that's really outside the employer's control. And so this is going to be the defense that employers are going to take when they have to engage in these mass layoffs or plant closings, or extend what were previously supposed to be temporary layoffs. You're going to rely on this when you can't provide 60 days notice. What you should make sure that you're aware of is that this is not an exception to providing notice. It's an exception to providing 60 days notice. So you need to make sure you provide as much notice as you can, and also tell the employees why they are not getting the full 60 days notice. A word of caution, none of these are blanket exceptions, even though the Department of Labor has said that these government closings may constitute unforeseeable business circumstances. If you face a WARN lawsuit, you are going to have to provide the particular facts and circumstances specific to your business to justify using that exception. There has been a notice lawsuit already filed. This one's filed in the district court in Florida against a large Hooters franchisee who engaged allegedly in a mass layoff on March 25th that affected almost 700 employees. They did not get 60 days notice. In fact, they got 0 days notice. A couple interesting points from this lawsuit, and it was just filed, so we don't, have the company's defense yet, or how the courts are going to handle this. But the lawsuit alleges that the Hooters franchisee should have known in January, 60 days prior to the March 25th layoffs, that COVID-19 was going to result in this mass closure. I think there's a few interesting dates from Florida. The governor didn't declare a state of emergency in Florida until March 9th. As of March 17th, restaurants were still permitted to be open and operating in Florida, albeit with some limitations. And it wasn't until March 20th that the governor ordered restaurants in Florida to suspend their on-premise services, but they were allowed to continue with takeout and delivery. And Florida's safer at home order I mentioned earlier didn't go into effect until April 3rd. So I think those are interesting facts that will undoubtedly be played out in this. There's one other point that I'm personally quite interested in. The complaint says that Hooters violation is even more severe because the company engaged in this mass layoff instead of taking advantage of a PPP loan and keeping their employees on the payroll. So it'll be very interesting to see whether businesses who opt not to get PPP loans are somehow penalized for making that decision. Let's just quickly, I know where we are, we're 15 minutes over on time here, but I do want to just quickly answer a couple COVID specific questions. If you are providing a WARN notice, but your employees are already on furlough or temporary layoff, or they're home working remotely, what's the best way to provide the notice? The answer is any reasonable method of delivery that is designed to ensure the employees will get the notice is acceptable under WARN. You can email a WARN notice to employees. It needs to still be specific to the employee and contain all the necessary information, but it can be delivered by email. Just a word of caution, if your employee was out on a temporary layoff, email may not be the best way to reach them because you may have turned off their access to email to ensure they weren't working during a furlough or a layoff. We get this question, we're a nonprofit organization, we're a large one, we have many employees. Do we have to comply with WARN? The answer is yes. WARN does apply to for-profit and nonprofit businesses. And then finally, I've had a few questions about whether WARN restrictions have been eased in light of this situation. And the answer is yes and no. The federal WARN Act has not been changed. There are no lifting of any of employers' obligations under federal law. Some states that have mini WARN Acts have engaged in some legislation or executive orders that have tried to make things a little bit easier for the businesses. So in states like California, New Jersey, and New York, the unforeseen business circumstances exception that I mentioned before, some states are adopting that to apply in their state law where that wasn't already an option. Some states are reducing the notice periods and easing some of the other requirements under their state laws. So the takeaway is, don't forget that you potentially have state law requirements in this area, and make sure that you're getting counsel on what the latest requirements are from any states that might be applicable. That concludes the content of our presentation. We do have, and the slide's not seeming to advance, there we go, we do have a few resources that we've compiled. There's so many out there, but here's a few that we thought were helpful and relevant towards the topics that we covered today. Quarles and Brady has a comprehensive section on our website for our clients or anyone else who wants to get some help sort of navigating through this environment and staying on top of what the latest changes are. With that, we are well past our original stop time. We did receive a lot of questions, but many of them I think came in earlier in the presentation, and we hopefully answered many of them with the content that we had already pre-slated for the rest of the presentation. And to be respectful of your time, we are going to end the webinar here in a moment. And if there are specific questions, you can certainly follow up with any of us. Our email addresses and phone numbers are here provided on the materials, and you can direct any specific questions that weren't answered to us. Gary, Chris, do you have any final thoughts?
No, Kelly, just to echo that, we were intended to answer questions. We've got a ton of questions. If we didn't answer it somehow in this presentation, feel free to reach out for any of us, and we're happy to answer it.
Yeah, thank you, Gary and Kelly. And I think this can conclude the presentation. Thank you.